Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Law of Torts. This topic is regarding the trespass. So, the legal maxim for trespass is quis et, or actually est you have to pronounce it. Quis est solum is est shine and actually you can stop here. That is est quis est solum means whoever owns a piece of land is est square. That means you can acquire, you can own it in the proper, use it in the way you like. This is the actual legal maxim, very lengthy, that's why I have cut it short. In brief, trespass means entering the premises of another unlawfully. Unlawful act committed on a property or wrongful entry into a property belonging to another. This is called trespass. Sometimes trespass may be taken as a nuisance also. Now, I will give you 3 case laws which are not mentioned in my notes. Basically, remember, in the law of torts, your intention, your knowledge, your motive, they are not at all necessary. That means, simply, if you ingress into the land of another, it is trespass. Normally, I told you that if you do not know that this land belongs to somebody, if you say sorry, okay, normally will be allowing, the court also allows. But if you pick up a quarrel with him, it is trespass because you have entered his premises, not an invitee. You are not a licensee. Unauthorizedly, definitely trespass. Now, first case law is Basely versus Clarkson 1681. B-A-S-E-L-Y. Basely versus Clarkson 1681. So, Mr. Clarkson, that is defendant, he cut grass from a patch of the land, believing it to be him, but it is the property. That patch of land is belonging to Basely. Basely filed a case. Actually, he is having no correct knowledge about the particular piece of land, but still, when it is proved that this land does not belong to him, he is held to be a trespasser and he was liable to pay, he was asked to pay compensation in the shape of unliquidated damages. Here the point is, court held it to be trespass, whether he knew it or not. Neeku telisina teliyakapoyina mee dantlo kaalu pedithe trespasse. Second case, Smith versus New England Aircraft Co. 1930. Smith versus New England Aircraft Co. 1930. Here, the flights belonging to the defendant, that is New England Aircraft Co. So, they are flying below 100 feet above the house of the plaintiff, that is Smith, and created nuisance. Actually, he was not able to have proper sleep. Actually, at that time, they used to go to the terrace of the house and sleep in the open air, but they are causing nuisance, and he filed a case of trespass and nuisance. That's why in the beginning I told you, it can be made as a case of nuisance also. Now, the court held it to be trespass because the flights are not supposed to fly below 100 feet. Now, I am going to tell you another negative example, similar situations. Bernstein, B-E-R-N-S-T-I-N, Bernstein versus Skyviews, 1978. This is a peculiar case where Mr. Bernstein, he sued the so-called Skyviews company for trespass by shooting pictures from a significant height, of course, maybe about 100 feet or so. So they may be having telescopic cameras, we don't know, but they are taking telephone photographs. He observed them from the beginning. Then he asked them, who are you to take photos from such a distance? Of course, nowadays Google will be taking the aerial photos and fixing up our houses and other things. They are permitted. Likewise, here the point is, they did not cause any nuisance. And secondly, it is not a trespass to take the photos for a public purpose. So therefore, the court held that it is not a trespass. Now, you can interpret in the present scenario. Suppose if some drone is capturing the photos, if you suspect it, you can file a case of trespass. If the drone is sent by the government of AP to do some spray work or something, then you can't do. So you have to understand the present scenario also. So please remember, these three case laws are for academic interest. I didn't think that such questions did not come in the part C of your exam. But anyway, for academic interest, they are good. And since I did not mention the same in my notes, I am reiterating through my video. Please read the case laws and enrich your legal knowledge. With this, I am concluding. Thank you very much.